Welcome to Credible Sources. Today we sit down with Senior Counsel Roysdale Forde, Attorney at Law Amanza Walton-Desir, and GECOM Commissioner Vincent Alexander on a range of electoral issues. First up, Amanza tells us about her impression of the amendments to the recently passed Representation of the People's Act, which intersects with the National Registration Act.
Our primary concern is the rush with which these amendments are being passed. And as we pointed out in the National Assembly, they are so weighty that they needed to be sent to a select committee for consideration. That was our first issue. I think it is important for us to understand that the Representation of the People's Act is a piece of legislation that touches and concerns the electoral landscape in Guyana and the ability of the people of Guyana to elect their representatives in a fair, transparent, and credible elections. And so I think given that importance, we said to the colleagues on the other side, we believe that they should be sent to a select committee. Of course, what the PPP does is to obfuscate matters. They are saying, oh, it was out there for consultation, etc. We have to understand that the process of parliamentary scrutiny is different from public consultation. Now that public consultations have taken place, and let me say that we have had our issues with what the consultation looks like, because the consultation that we were invited to was a 3-hour presentation, 2.5 hours for which the Attorney General spoke. And then when our representatives tried to make representation, they were curtailed. So that was their idea of consultation. Having said that, coming into the National Assembly, there is a provision that we can send these bills to a select committee where they would be scrutinized clause by clause, and we would understand the rationale behind the pieces of amendments. Those records, and I suspect that this is why the PPP did not want them to be sent to a select committee, Sharon. Those records are there. They are kept in the Hansard, and the verbatim records are secured for historical purposes, so that at any point in time, any citizen of Guyana could go to look back to understand what the intention of the Parliament was when it made this particular amendment. I suspect that they don't want that level of scrutiny, and so of course, using their one-seat majority, they powered it through the National Assembly, and it is now law. For all intents and purposes, replete with the flaws and the shortcomings that we pointed out in the debates.
Nomination Day 2022 has been cancelled. We talked with Senior Counsel Roysdale Forde and Commissioner of GECOM Vincent Alexander on the decision by the Guyana Elections Commission.
Aware that GECOM recently issued a press statement indicating that they would be deferring or cancelling nomination date, which is supposed to be the 12th of December 2012. But I believe at this stage, we are not in a position to really rejoice at this time. The same statement issued by GECOM indicates that at this time, they still intend to pursue the provisions of Section 24A of the Local Government Act to resolve and to correct the list. I believe that GECOM continues to go down a road that will lead to a list which is still not in compliance with the local government election law. The list as prepared by GECOM was not prepared under the local government elections law. No order was made under Section 8 of the local government elections law. They purported to act under Section 5.6 of the Election Laws Amendment Act, which deals with a list prepared under the Election Laws Act and provisions associated with that act under the Representation of the People's Act. So at this time, I believe that GECOM, whilst they would have recognized that the list is flawed, the list is bad, the list is bloated, the list is dirty, and it cannot be used in its current format, I believe that the efforts and mechanisms that they intend to employ to correct the list cannot result in a list which is still acceptable and in accordance with the legal provisions governing a list of register of voters prepared under the Local Government Act. GECOM seems also to have come to the conclusion that the Minister of Local Government could not exercise the power to demarc constituencies within local authority areas. So there are two substantial areas which GECOM would have turned and altered their position in this regard. Sure, the first thing that GECOM should be doing and the Guyanese people should be calling for is a new chairman of the Guyana Elections Commission. We should be calling for a new chief elections officer of the Guyana Elections Commission. They have presided over this catastrophe, this embarrassment, and this mess. So we can't necessarily ask them to correct it. Even in this process of correction, they're still erring substantially in a manner that cannot result in a list being properly in compliance with the law. In terms of the Guyanese people and what they need to do, they need to go to the regional offices, go to GECOM offices, and point out people who are not in your communities. Every person that remains on the list, every person who's not ordinarily resident in your community is the source of substantial fraud, is the source of potential substitute voting, and that cannot be allowed in your community. The existence of those persons on any list destroys your right, destroys your voice, and destroys your choice. This is about local government elections. This is about your protection of your rights in your communities. It is that under the general and regional election system, the laws were passed, I believe, on the basis of the acknowledgement of a residency requirement. The local government elections law specifically says in a much more great and clearer way that residency is a requirement for you to exercise your franchise in the context of a local authority area. So there was a great consistency between what the law says or said in relation to residency, both at the general and regional elections level and at the local authority level. And the laws proceeded on that basis. Even Section 5(6), which they're purporting to use of the Election Laws Amendment Act, proceeded on the basis that resident and being resident in an area was a requirement. In 2018, the PPP, through Nandalal, I believe, filed a legal proceedings in the name of Christopher Ram and the Attorney General, when for the first time the Chief Justice concluded that under our Constitution and in accordance with our electoral laws, that residency was not a requirement. So the requirement for an election at the national and regional level no longer included the laws in relation to residency. So whilst residency remained in Section 5(6) of the Election Laws Amendment Act in relation to local government extraction of a list, because that section says that GECOM, if it wishes to exercise its discretion, can use a list prepared for national and regional elections for that purpose. So that requirement of residency no longer existed. So by extracting that list in which those elements are no longer present and applying it to local government elections where in the context of that law, residency is the greatest determining factor, that list cannot be used for local government elections. Further, it is important to observe that the section under which they purported to act is a section that provides GECOM with the authority, if it wishes, to proceed to extract a list which now is no longer premised on residency, to use it for local government elections when there is a specific law, the local government election laws, which specifically provide that residency is a requirement. This means that GECOM is being given by these laws the power to determine the qualifying factors for qualifying under these local government elections, because 2016 election was done on the basis of the Local Government Elections Act, where residency was a requirement. On the basis of the 2018 local government elections, the same thing occurred. But at this elections, GECOM purports to exercise a power which was never used before in a law passed in 2000. That is why I went back to the little historical analysis as to what it meant in the context of residency. So they're now using a law which now referred then to residency, but no longer refers to residency, to be used in a law now, in a legal regime that requires residency as a requirement. So GECOM effectively, by that change in interpretation of the law by the Chief Justice, is able to determine different standards, different qualifying standards for persons to vote at different elections. If this was allowed to happen at these elections, it would have been on the basis of everybody on the list, because that is what effectively the Chief Justice said. So the next elections, another commission could have said, listen, we want to now go on to the local government elections law. We can't have an electoral system without that degree of stability and permanence and consistency which is required in an electoral law. GECOM can't be the authority to alter at its whims and fancies and its discretion what would be the criteria for persons to be allowed to vote at local government elections.
One of the issues is the issue of demarcation. The laws of Guyana clearly and unambiguously provides for the GECOM to be responsible for demarcation of constituencies in local government areas. For whatever reason, the minister embarked on that exercise as if he had the authority. When the issue was raised in GECOM, the commissioners appointed by the government said they had done research and had concluded that the commission had acted correctly. We challenged that, presented a counter argument, and the chairman today gave her position, which concurred with our position, that the minister has no such authority, that the authority for the demarcation of constituencies solely resides with GECOM. So that is one issue which is outstanding, which has been resolved. And obviously the resolution of that issue will lead to other things, because it means that any demarcations done by the minister are now null and void, and GECOM will have to address that and to go about doing its own demarcation. The second issue had to deal with the question of the list. We have been saying for the longest while that the preparation of the list should have started with a claims and objections in relation to the voters list for the local government areas, so that objections and claims could have been done specifically in relation to the constituencies and the local government areas. Unfortunately, that is not what was done. The list was prepared in a manner as if they were preparing for a general election, and at the last moment they were now seeking to do some exercise that would facilitate what should have been done at the inception. The CEO, over the last weekend, came to the conclusion that he, in his words, should appease the stakeholders by responding to the contention that what was being done was not affording voters the opportunity to go into claims and objections in the manner in which they should. He therefore brought to the Commission a proposition which he said was partly influenced by the fact that APNU AFC had approached the court. That matter was discussed today. For all intents and purposes, it was agreed that action need to be taken in response to what he proposed, taking into consideration what's before the court, and that action in any circumstance would take time, and therefore we cannot proceed with nominations there as previously intended. There's a possibility, more than likely, that we cannot proceed with the date for elections as intended, but the only decision finitely taken was to postpone the day for nominations, subject to internal work and discussions that will then produce a new work plan that will then indicate when we can do nominations vis-a-vis a date for elections. Of course, one may say it's a calamity. I think it has to do in some regards with the competencies within GECOM to have stepped off on the right footing. It also has to do with the fact that some commissioners were supporting what was unfolding and therefore did not lend to the kind of decision making that could have corrected this, because Commissioner Corbyn from the very inception was indicating that they were on the wrong track in relation to the preparation of the list. That in itself led to 7 to 8 iterations of the plan. 7 to 8 iterations of the plan. without necessarily addressing that critical issue the way in which it should have been addressed. So we have now gotten to the point where if we go forward, the court may well intervene, and so an attempt is now being made to correct what could have been corrected if GECOM had listened to the arguments of Commissioner Corbyn all along the way. Well, there's a difficulty in calling for the resignation of the chair in the context of what our Constitution provides for. Well, resignation, yes, because that means that she will resign. But the chair is someone who is not removable except for resignation in fact. And I think that indeed there is an issue here because a chairperson can give leadership to a process that can arrest things which are not going right. And I don't think that that kind of leadership was indeed given to the process. Some weeks ago I made the point that we have vacancies and that the CEO is overloaded, and being overloaded would in fact allow the Peter Principle to come into play. I think the Peter Principle has come into play because we need to have a DCO, we need to have a voter civic and education manager. Those people are not in place. The CEO is trying to do all of that himself, and separate and apart from his own level of competence, it has brought us to a situation where the Peter Principle has obviously affected the operations of GECOM.
As we discuss electoral issues, we turn our attention to the issue of gerrymandering. GECOM has recently decided that the Minister of Local Government, Nigel Darmlal, had no authority to change boundaries.
GECOM found itself in is that it relinquished the power vested in GECOM to determine the consistency boundaries within a local authority area. A local authority area may stretch for a couple of miles, and there will be constituencies within a particular area. For example, at the press conference, I referred to the Union Local Authority area in Region 5, and there are 9 constituencies within such a local authority area. What the minister purported to do was to assume unto himself powers to determine where those boundaries exist within a local authority area. So our position is that that power does not vest in the minister. It is an electoral power. And because it is an electoral power, and because of the system that has been created under the Constitution to ensure that we have free and fair elections, we as parliamentarians and as the governments, successive governments, enacted legislation on the premise and on the philosophy that GECOM will be the party who will determine boundaries, because a government is a participant in election. So imagine the government itself fixing boundaries within local authority areas to maximize support in their areas in which they enjoy them and to minimize support in their areas. Therefore, they could control, they could multiply constituencies in which they have support and reallocate boundaries, probably covering large swaths of areas, great populated areas, into ramming them into small numbers in a constituency area. So that was why GECOM, I believe, finally came to the conclusion, in recognition of what is really their purpose under the Constitution, which largely GECOM fails to do anyway, to recognize what is their purpose and to act in accordance with its purpose. But these are a few flashes of some degree of recognition of their purpose under the Constitution. But I just want to say to the Guyanese people that I remain completely unimpressed by this newfound consciousness by GECOM.
The fact is that I believe that they're seeking to gain an advantage. It is not about leveling the playing field. I think it is about gaining an advantage. And I'll give you some examples of what I mean. Now, what we have to understand, and if you were a part of the parliamentary debates, I think the PPP needed to be reminded with alacrity that they do not hold the moral high ground. when it comes to this issue. I think their attitude is one of, oh, we are trying to save democracy, etc. The reality is that electoral reform is something that has been called for in Guyana for decades. And so we have to start out on the correct premise. If we're going to use 2020 as the premise for electoral reform in Guyana, then we would have done ourselves and this nation a disservice, because the weaknesses that inhere in our electoral system were there pre-2020. And so we recall a number of instances where electoral malfeasance took place under the PPPC. What they would want for our people, for the people of Guyana to disregard is the fact that these events actually occurred. And so no, they do not get to, like I said in the debate, be the moral arbiters of this. Now, this is why it is important that Guyanese become involved, because Sherrod, we could go down the road of pointing fingers at each other for the next 20 years. That will get the people of Guyana nowhere, it will get the country nowhere. What we are in urgent need of is sound, well thought out electoral reform. And it cannot be that the PPPC will continue to use the tyranny of its one-seat majority to impose what it believes is electoral reform to the exclusion of the voices of every Guyanese who wishes to have a say. So we have to continue to bring this information to the people. Now, one of the principal issues that we have is the draconian measures and the fines and penalties that are contained in that bill. It is ludicrous. When you look at, for example, the penalties for murder and for rape, that you are trying to equate electoral offenses to those. And so in those instances, the fines and penalties for electoral issues outweigh, for example, the penalties, etc., for murder. There is no legislative congruence in terms of what the PPPC is doing. But we understand that they're using it for political mileage. In their haste to gain political mileage, however, what they are sacrificing is the management of our electoral processes, because those draconian fines and penalties are at this moment deterring capable, competent, qualified people from becoming involved with GECOM. Because if I, as a polling day worker, I make a genuine mistake, there's no room for me to mount that defense. If it happens, you face the consequences. And so people who are capable and competent will be dissuaded from interacting with GECOM. The corollary of that is, or the flip side of that is, that what it does is that it allows people who have political motives and connections to be the arbiters to be the administrators of our electoral processes. And like I pointed out in the debate, Sherrod, the PPP, they've demonstrated the ability to protect those people who they view as their supporters when they do wrong. So if they don't perceive you as their supporter and you're working in GECOM and you make a mistake, something happens, they will say, prosecute that person to the full extent of the law. If their person that they believe support them does the same thing, they will likely say, look, do not invoke legal proceedings, because this is something that we have seen. We have seen them do this. So it's not conjecture. And the other thing is, this is affecting GECOM's ability to man elections properly, because, for example, the PPPC administration objected to 72 officials for GECOM that GECOM identified as polling day staff for the upcoming LGE. The CEO said, look, if I am to remove these people, we will be unable to have elections. So they are creating real manpower issues for GECOM because they're not thinking these things through. At all times, the law must seek to accomplish a balance between the mischief that it is seeking to curb and the effects of the provisions of the law on the proper administration of our elections. And they failed to strike that balance. And I think in the future, unless we're able to change these laws, our elections are going to suffer. What we do know is this, in that in most of the Caribbean Commonwealth countries, the delineation of boundaries is not a ministerial function. It is a function carried out by, for example, their electoral bureau or their electoral apparatus. So for the minister here to be changing boundaries really does appear to us on the face of it to be in contravention of the law and not in keeping with what the best practices have been in the Caribbean. I know that we have made a number of submissions to GECOM through our commissioners on the matter, and they're supposed to be deliberating on that today with a view to returning a decision. The other issue that we have, of course, is this issue of the list that was prepared for the local government elections. As you know, the APNU AFC Chief Scrutineer, Ms. Carol Smith-Joseph, would have initiated legal proceedings asking that the court take a look at this issue. Now, of course, GECOM has since, through the CEO, backpedaled, and they have realized that they did not properly extract the LGE list, or they did not subject it to the correct procedure. Now, Sherrod, this is what is troubling about this. This is not something that they were unaware of. This is a matter that our commissioners would have raised time and time again at GECOM meetings. And so what it demonstrates is what we've been talking about all the time, which is the politicized nature of GECOM. The way it is currently constructed makes it unfit, as it were, to engage in any kind of consensus decision making. More so particularly when you have a chair that appears to be only inclined to vote a certain way. It really is undermining the strength of our electoral system. So it is unfortunate that these matters, when they are raised, even within the system, you see an unwillingness to course correct. And we have to resort to the court in order to be able to bring some semblance of sanity to this situation. And it's really unfortunate, but we're glad that they have seen the error of their ways. But as I think Senior Counsel Forde indicated, this matter will proceed and the court must be able to, once and for all, bring some kind of order to this issue.
British High Commissioner, Her Excellency Jane Miller, recently waded into the issue of the voters list, saying that in her impression, from what she knew, the list was good enough to proceed with for the next election. GECOM has recently walked back on its own decision to proceed with this list. We spoke with Senior Counsel Roysdale Forde and GECOM Commissioner Vincent Alexander on this very issue.
This is a very important occasion. The fact that GECOM itself has essentially discarded the list, has walked back from a process that it would have been initiated, which all stemmed on the heels of that very profound statement by the British High Commissioner. The High Commissioner must now understand that she was misled. She must now understand that whatever she would have been told by the government, whatever reassurances she would have been provided by the Guyana Elections Commission and indeed to the other members of the diplomatic community, that GECOM has failed to conduct the elections in accordance with the law. GECOM has failed to prepare a list, a register of voters in accordance with the law. You know, it is very important that this event occurred before the election, because from time to time we see the diplomatic community and indeed observers making very profound statements about the conduct of our elections without necessarily arming themselves and equipping themselves with both the information and the circumstances under which the lists are to be prepared And in view of what is happening here, I believe that the diplomatic community now should find themselves in a different position in which they now understand that GECOM is failing the nation, failing to provide free and fair elections, failing to provide the opportunity for all Guyanese to participate in this electoral process. And without any fair electoral process, our economy could grow as much as it wants, but at some point, and I believe in a very short period of time, the international community and the investor climate will rapidly change, which will in turn deny the Guyanese the full rights and full opportunities that they're supposed to be enjoying at this time.
Well, she did not refer to the situation we're now talking about. She was referring to the content of the list in terms of it not being bloated. That's my understanding of what she was saying. But she was patently wrong, patently misled in that regard, because nobody can contest the fact that there are thousands of people on that list who are not necessarily known to be alive, particularly those who died overseas, for which we have no mechanism for taking the names off of the list. I think the British High Commissioner placed her foot in her mouth when she did that. And she ought to have been more cautious as a diplomat, even if she felt that was the case.
That's all we have for you. Until next time, thanks for joining Credible Sources.